Do you ever wonder why you see those yellow caution signs everywhere at retail stores, like caution, slippery floor, caution, hazardous condition? It's not just protection for you, it's legal protection. Hi, I'm Matthew Konecky, and in this video we're going to uncover why those signs are there. In this video, we're going to cover the 7 hidden hazards at retail stores. Owner's duty under the law, mode of operation theory, key pieces of evidence that you have to win your case, Florida Statute 768-0755, which is the owner's negligence statute, comparative negligences, and why it could reduce your recovery. And stick around to the end because we're going to discuss the 3 key pieces of evidence that is crucial to your case that you have to have in a timely manner. So let's dive into these 7 areas of hazards inside a retail establishment. And the first one that I want to talk about are floor transitions. So floor transitions are where either there's a raise up, like a step up in a store, or a step down. Because if they're not clear, if there's similar flooring that looks like it's even and you take that step, you might fall forward on a step down, or you might trip forward if it's a step up and you don't actually do it. So that's the first type of common hazard. It's a floor transition. The second is an unsafe display. Now you might say, well, what's an unsafe display? Think about this. In every grocery store aisle, there's an end cap at the end where they have a nice display. Maybe it's seasonal, maybe it's for Halloween, maybe it's for Easter. But those end displays also a lot of times have decoration, or they have a lot of the same things that are listed that are common, but at the very bottom they have some of the bigger items. So for instance, if there was a bigger box at the bottom and it is not really visible because you're looking up and you go to turn the corner to go down the next aisle and you trip over it, that is an unsafe display. Number 3 is you might find that there's clutter in a changing room. A lot of times when you go to a retail establishment and you're going to go try on clothes, space is always a commodity. So those fitting rooms are often very small. So if someone had went in there and changed and just left stuff in and an employee didn't clean it up or remove that, and there's something on the ground that you didn't see, be a handbag, it could be other clothing. If it's something that caused you to trip and fall, that's a hazard. Number 4, a slippery entrance or exit. Hey, we live in South Florida. It rains all the time. So we know when it rains, there should be good slip mats inside a building. So when you're transitioning from outside, bringing water on your shoes in, you want to be able to dry off your feet even before you go into the store, but certainly after. Because without mats on the ground in rain, you're going to see a lot of potential slip hazards on there. So this is a common example of a retail hazard, is the coming in and out with slippery entrance. Now, number 5, refrigeration leak. You can see this all the time when you go to your local mini mart or convenience store bodega. If you go to the back to get yourself a soda out of the back and you've got a leaky refrigeration compartment, or the ice chest for which you're buying bags of ice, someone leaves the door open, it causes condensation, or quite frankly, tubes are leaking. It's going to be on the ground. It's maybe hard to see. You can ultimately see a retail hazard there. Likewise to wet, slippery floor, wet floor after cleaning. As we stated at the beginning of the video, why do we see all of those yellow caution? When custodial people are cleaning, they want to put those out so that that they're cleaning, and it's visible when people walk through the store. They know to slow down, to look for a wet floor, because it may not always be visible. And then 7 are hidden spills. This happens all the time at the food court at the mall when they're giving out free samples. When you go to your local grocery store chain, when they're giving out samples, things may fall off the toothpick, not make it into the trash receptacle. If it ends up on the ground, that could create a slip and fall hazard, whether it's a piece of fruit, a piece of ice, yogurt, something like that. Anything that would create a slip on your shoe and the floor, that's a slip hazard. Now that we've talked about the 7 hidden hazards of a retail store, let's talk about the store owner's duty. First is a routine inspection. They have to inspect their premises. They have to go around and look to make sure that there are no transitional spots, or if there are, that they're well marked, that the store is clean, that there are no problems with the end caps. All the things that we've talked about is a store owner's duty to make sure that they've gone through and make sure those hazards aren't there. So number 2, the store owner has a duty to clean. And as we stated before, that they have a duty to make sure that the floors are clean so that you aren't slipping and falling, that if there is debris, you're not tripping over it. And in fact, we're going to talk more about this when we talk about Florida Statute 768-0755, because it talks about more in detail about the owner's duty. Now, another part of their duty is to put up warning signs. So if we talk about those transitions, that they've, if there is going to be a transition, that it's marked that there's going to be, or those yellow hazard signs that we talked about at the beginning. Now, it's not just enough for a manager to be the one to do the routine inspection and prompt cleaning. The staff needs to be trained about, you know, what happens when there's debris on the ground, how to clean it up, how to mark it, how to make sure that the customers are safe. And finally, they have to document. It's not just enough to clean a store once and say, well, it's clean, because as you know, when you go to the grocery store, there's so much foot traffic. There's stuff happening all the time. And so what we see a lot of times is supermarkets call them sweep sheets. They have sheets of when an employee goes through and cleans the aisle, and they mark which aisles they cleaned and what time they cleaned it. And why that's important to have is, we're going to talk a little bit more about that in 768-0755, is they have to clean a spill within a reasonable time. I always give the example in a slip and fall case to a potential client. So when is a grocery store liable for material that's fallen on the ground? Well, if it's not cleaned up within a reasonable time. But what is a reasonable time? So I'll give the example. You're walking down the aisle and there's a person in front of you with a toddler inside the cart, and the toddler is just grabbing stuff off the aisles and throwing it down, or is eating its own food or a yogurt cup or something and then throws it on the ground, but yet you don't see it, but you're 10 steps behind it. There's no expectation that a grocery store manager or custodian is going to be able to follow a toddler around the store. So that wouldn't be a reasonable time. But let's just say that the same scenario happens and you're not following that toddler. The toddler throws something on the ground and it's there. And then an employee walks by and looks at it and says, oh, that's there, and just keeps walking, and it's not cleaned. And then 10 minutes later go by, and now there's more people that walk by and the material's getting stickier and more visible. And then another employee walks by and it's now 25 minutes later and the same material is on the ground. There's going to be a lot more liability. They knew or should have known that that material or that substance was on the ground and it was a slip hazard. So that's where we kind of look at where they have a duty to document that they've cleaned it, because if they have good sweep sheets to saying that they did this all the time, then they can say they don't have knowledge of that slippery substance on the ground. Now let's talk about the mode of operations theory. So the mode of operations theory really kind of was replaced by statute 768-075, but basically what it said was that the way the business conducted its business created the hazard itself. So kind of like self-service businesses, get your own sodas, where soda just drops down. If there's no one looking out for spills or anything like that, that could be what we kind of think about the mode of operations. Or if their plain mode of operation is just terrible, or they don't clean, all the things that we've talked about before, that is the bad mode of operation. But really what we're talking about now in Florida Statute 768-075 is what the duties are of the store owner, and we're going to talk about 768-075 in detail now. So the Florida legislature enacted 768-075 to deal with transitory substances on a floor in a retail store. Transitory substance is something that doesn't naturally occur there. Let's just call it a slippery substance. So let me read the statute to you. says 768.075 says if a person slips and falls on a transitory substance in a business establishment, the injured person, that's the plaintiff, must prove that the business establishment had actual or constructive knowledge of the dangerous condition and should have taken action to remedy it. Constructive knowledge may be proved by circumstantial evidence, and we'll put a pin in that and let's just discuss that. So it used to be that prior to this statute, that if you could just say the mode of operations was, hey, we know they operated in a bad way, that's why the plaintiff fell. Now, this statute says that the plaintiff must show that the owner had noticed that there was a problem and did nothing about it, or should have known. Okay? So it's not enough to say, well, this is the way that runs, and of course, that's why I fell. So it actually puts the onus on the plaintiff. And this was a huge change. Now, with slip and fall cases, a lot of cases can get dismissed if the plaintiff can't show it. They can't even get it to a jury to make that argument. A lot of cases could get dismissed by summary judgment. And so when this statute was enacted, it actually cut a lot of potential slip and fall cases. So let's talk about the actual constructive knowledge means that there's enough evidence to show that they should have known. Establishing that the dangerous condition existed for such a length of time that the exercise of ordinary care of the business should have known about the condition. So let's talk about that in my previous example. The child throws yogurt down in the aisle, and what happens? It's there and it starts accumulating dust particles, or it's been there, or there's a security camera that shows that the employee walked by it and just didn't clean it up. There's where constructive knowledge. B, that the condition occurred with regularity and therefore foreseeable. So let's use another grocery store example. Let's just say that in the produce aisles, there's a cart of produce that always has ice. And every day at 5 o'clock, at the kind of end of the day, there's always condensation and maybe even a little bit of drippage there, and they know about it, and every day they mop it up, but on one particular day they don't, and someone slipped and fell. That could be where they would have constructive knowledge. So now that we've talked about Florida Rule 768.075, let's talk about what comparative negligence is. So comparative negligence means that even if you're partly at fault, you can still recover. Now, Florida has recently changed its statute under House Bill 837 that says that if a plaintiff is 51% responsible for their own injuries, they can't recover at all. So it's really now modified comparative negligence. But just hear me out. Let me give you a better example. So let's just use the example that we had stated before. There's a transitory item on the supermarket floor, and without a doubt, they have actual knowledge of this transitory item and they are responsible. They did not clean it up. But you're at the supermarket, you're in flip-flops, and you think it would be funny to run down the aisles. You are partly responsible. You're maybe not be wearing good footwear to be running in, and you're not looking where you're going. If you slip and fall, you are partly responsible. Now, if a jury says, yes, but that substance was there, but we find the plaintiff 25% at fault, you could still recover your damages that are proved at trial, but your recovery would be reduced by that 25%. That's what comparative negligence is. It reduces the amount you actually get out of your jury award by how much responsibility the jury gives you. Now, as I said before, if you are more than 50% responsible, you do not recover a thing. But if you are 49% recoverable, you could recover 51% of the damages. So that is what comparative negligence is. So it's not a black and white, 100% at fault or no fault. It's comparative. So let's talk about the must-have evidence you need for your case. You not only have to have the transitory, sort of the defective condition, as we talked, 7 hidden hazards. You have to have documentation under 768.075. You have to have the owner with knowledge or constructive knowledge, and most importantly, you have to have injuries. Because if you slip and fall and aren't injured, you don't have a case. Your case is only worth the value of what your injuries are. So in order to determine that, it's going to require evidence from your doctors, your physical therapists, maybe a life care plan if the injury's large enough. It's having that kind of information to give to a jury to help make that determination. Lastly, here are the 3 time-sensitive pieces of evidence that you should get if you're in a slip and fall accident. You need to see if you can secure security videos. Now, I will tell you, Florida's #1 grocery store chain will not turn over a video unless they're subpoenaed to in court. Good luck on trying to get that before you file any claim. But if you are, for instance, at a gas station, or you're at a place where another business might have a security camera, you could go to that place and see if you could secure it. I have actually done that in a motor vehicle accident case where I went to a local pawn shop who had a camera directly on the situation to help prove our case. Number 2, get photos of your footwear, because if you are wearing good footwear, save your shoes, show that you've got good tread, that it didn't matter that you've got good sneakers on, that it wasn't your fault for the footwear that you're wearing. Likewise, if you are running around in the slippers of that they give you after you get your pedicure, that's not great footwear. But it is important to secure that because you don't want to have a spoliation of evidence claim. Make sure you keep the footwear that you have and don't get rid of it because you think it's bad, because that could create problems in your case later on. Also, witness statements. If you slipped and fell on something and somebody witnessed that, if there are no cameras or no one's willing to give you that footage, it's important to have eyewitness there. So if someone says, "Hey, I saw you fall, I'm so sorry, what can I do to help?" You can ask them their name, their telephone number, and their address and the email address, because you may want to contact them later. They will be the ones who benefit you the most, because that store manager who saw you slip and fell and had you fill out a documentation form, he's not on your side, but an independent witness may be. I hope you understand now more the importances of, 1, not only documenting your case, and 2, where the hazards are located. If you want to know more about personal injury cases or slip and fall cases, we have a guide called "What the Heck's My Case Worth?" It's available on our website. You can click here to download a copy, or you could give us a call to talk about your case. In our next video, we're going to talk about why waiting to file a claim could cost you more money.